Directive 2010/64 guarantees to all requested persons the right to benefit from interpretation and translation in European arrest warrant proceedings. And since the likelihood is high that the requested person doesn't speak the language of the state where the proceedings are held, the right to interpretation helps them communicate with their lawyer. But they also have a right to translation of all essential documents that help them understand the proceedings they are in and why they are in them. But there are currently huge implementation gaps of this right in practice.
It's crucial for every defense lawyer to have access to interpretation and translation in European arrest warrant proceedings. I'm defending German foreigners. They speak English, they speak German, they don't speak at all Italian, they don't understand Italian. The charges are huge. They're facing 20-25 years of prison time and the fee of hundreds of thousands of euros. It's something like 30,000 pages case file. And what did we get? We get just the official notification of the charges. It was a 2 pages notification in which the indictment and the charges were translated.
Most of times, there's the lawyer from the executing country and the requested person, they don't talk the same language, so it's the only way to communicate with them.
The elements of the case file that have to be translated, they should be defined. What does essential act mean? What is essential? Essential for who? If it's essential for the defendant, I think that the defendant should have a voice in deciding which is essential or not.
Many member states have failed to implement the directive, so there's often no mechanism to check the quality of the service and how negatively interpretation and translation can affect the rights of the requested person. And this can even result in the requested person not being able to fully understand and participate in the EAW proceedings against them.
Accuracy in interpreting, I think, is probably the most important thing of all. But if an interpreter hasn't been trained, they may not even realise some of the mistakes that they're making. There's no training for interpreters available. There's no accreditation system either to establish if people are competent or not. And if you add in the low rates of pay to that mixture, it's going to be very, very difficult to get competent people.
Legal terminology is not always easy, as you well know, and different national orders have different national terminology. And I think that maybe interpreters do not need a whole 3 years course on criminal and any other kind of law in order to become legal interpreters. They need to understand the essentials of each legal order.
Where I'm representing a requested person in the executing state, it's often that we will receive copies and translations of documents which are very poorly translated, and it's an added issue because we usually have to have these translations redone, refixed, and in order to get a proper picture of the case against our client.
EU law requires member states to ensure access to free language assistance, but the resources available at the moment are very limited and don't cover all the needs of the defense in EAW proceedings. And this often means that those requested persons who have the financial means to fund additional interpretation and translation are in a far better position than those who don't have the financial resources for this.
The lack of resources is one of the main causes of winning or losing an European arrest warrant. Having money implies that you can translate all the essential documents, or not even essential, that you can have a private interpreter whenever you can. In case you don't have that money, you cannot translate the documents, and the communication with the requested person becomes much more harder, because you have to improvise in order to have a conversation with him.
In my opinion, the means that a requested person has and their means to be able to pay a translator and put up a strong defense often is the difference between being surrendered or not. And this is obviously very much not the right way to go. This is plainly unfair, and whether a case against someone succeeds or not should never ever depend on their means and whether they can pay for an adequate translator or proper translation services.
Having access to quality interpretation and translation services is a precondition for the effective exercise of other rights under EU law. So member states must establish a mechanism that ensures that interpretation and translation services are available as required under EU law.
Generally speaking, my impression is that judges and courts, they see the interpretation and translations right as a hindrance, as an obstacle to the fact that the things must move on, and they must move on efficiently. But efficiency is not a thing that could balance the fairness of a trial. Sometimes the trial has to be not efficient. It takes time to take the right decision. So why can't the government think about a mechanism which guarantees to the defendant an interpretation and translation of quality?